morning, everybody. How's everybody doing? We're running a little late, so we'll speak fast. But we do have a lot of comments today. But wanted to thank you all for coming to the session. I'm Gunderson with Citgo Petroleum. I have Greg Luna, who is our Senior Legal Corporate Counsel, and also Todd McClelland, who is a partner in legal counsel. And he's actually Global Head of Privacy and Cybersecurity for the legal firm McDermott, Will & Emery. So today, we want to talk about managing third-party vendor security from the business perspective. You know, unfortunately, we've seen many data breaches where the service provider has been the root cause. And so as a company, we ask ourselves, what can we do to manage this risk and mitigate it? So today we're going to share how we've focused on security, not only through the traditional methods, but also from a business perspective, because we really need to protect ourselves and to try and mitigate that risk by adding clear and concise contractual language so that both parties really know and understand their responsibilities. So Todd, why don't you kick it off for us and talk about how we get started? Well,
first let's make a quick comment. We have a lot of verbiage on this slide.
Yep.
And so you're going to see a lot in our presentation today. We're lawyers. It'd be remiss if we didn't just throw a lot at you. But in any event, we're going to cover kind of a subset of this. So we hope this is something that folks can pick up and leave behind and take with them.
We wanted to give you something that was of substance.
Perfect. So the first thing we're thinking about when we're dealing with a service provider, dealing with is such a harsh way to start this, I guess, but it's a question of, for PCI purposes, are they in scope or out of scope? Now, this is not a new concept. There's been guidance for years dating 2017 and before that. But certainly what is new with the new PCI 4.0 standard is the extent to which the SSC has gone into laying out tests by which we can assess, is this vendor in scope or are they out of scope? And that's really important contractually and how we work with this service provider going forward. Now, even if this service provider we're dealing with is not in scope, I think the PCI DSS standard is a fantastic standard to still think about, to incorporate some of the controls that are in there. It's very mature, very well thought out, something great to think about. But if they're in scope, certainly it's an obligation. There's new requirements in Section 12 and how we're going to work with this vendor, and those are all things we're thinking about. Now, I'm a lawyer, so I'm also thinking about the legal angle of this, and we're going to go through during the course of this presentation talking about some of those legal considerations in the contract. Now, one of the first legal considerations we're thinking about is breach notification. And for those who work with service providers, we get into that game, who's going to notify me when, and Greg's going to walk us through in a second some more of the details. But from a legal perspective, what I'm first thinking about is, what does this service provider need to do to facilitate my compliance? But compliance with what? First, we've got the payment brands. They all have different standards. We need to be mindful of those, different timing notifications. When do I have to engage a PFI and a variety of other things? But then I'm also thinking about legal requirements. In the US, we have 50 different state breach notification laws. In different industry verticals, like healthcare, for example, we have HIPAA and other notification obligations there potentially. But then what if you're a global organization? If you're in Europe, you've got GDPR. There's new requirements in China and Brazil and pretty much anywhere around the world. India, I think, has now a 6-hour notification requirement. So what we need to think about with our service providers is, what do we need to have contractually for them to facilitate our compliance? Now, Greg, why don't you walk us through some of the more detailed thoughts you might have as we think about how we work with our service provider and team this up contractually?
Sure. Thank you, Todd. So you may catch a theme here, and the theme is that there's going to be a breach. And so you shouldn't really be thinking that if we do everything right, we're never going to have a breach and we don't have to worry about it. A breach is going to occur. So the question is, what do you have in your contract in order to deal with that? So what we have up here on the screen, and in each one of these blocks could really be a screen on themselves, and I could talk 5-10 minutes on each one of them. But these are the sort of things that you're going to want to have in your contract so that there are no ambiguities. The terms and conditions of which party does what, when it does it, is already there in the contract. You don't have to rely on what you think and what maybe the other party thinks is a good practice. It's in the contract. So this is just, as Todd mentioned, the first thing that's going to happen is there's going to be a notification trigger. Who knows of the breach? What do they know? What is their obligation to tell, and to tell to whom? What is the timing of that? When does that party notify another party or some other party? And I would really suggest that this third one, cooperation, is really the most important one, because one party is going to know more than the other, and they're going to have a contractual duty, an obligation to share that information with the merchant, or maybe the other way around. The merchant notifies the provider. So once you have that information sharing, you can start thinking about what it is that needs to be done in terms of a forensic. How did the breach occur? How severe is it? Who do we need to notify publicly once we have an idea of who's been affected by that breach? So then you start thinking about the fun stuff, which is who's responsible, who's going to pay for that. And I'll discuss that a little bit later in terms of risk allocation of who's responsible for what.
Thanks, Greg. You know, both of you had kind of mentioned our service providers, and they also have their service providers. And so PCI DSS 4.0 is one of the first times that we actually see quote unquote fourth party risk. And so in those fourth parties are also in your scope for PCI compliance. So make sure that your contracts not only include what needs to extend to your service providers, but also what needs to extend to their service providers. And sometimes in some of the contracts that we've negotiated, they need to shore up their service provider contracts. And so we've actually put in dates, timing, what happens if you don't meet those time frames to shore up their service provider contracts. Also, who's going to be notified? Is that fourth party going to cooperate with the PCI forensics investigation? You know, are they going to allow us to go on site to investigate? Those are all things, again, that we cannot stress enough that you should have in your contract ahead of time. You don't want to kick the can down the road, because when something happens or the fur is flying, that's probably the worst time to be trying to negotiate these items. So, and I would also note that there are many laws and regulators that require us as merchants to pass on those obligations to our service providers. So again, make sure that you're also talking about third and fourth party risk.
You know, that's a great point, because with the supply chain these days and all the breaches we're seeing, a breach here can have a ripple effect down the supply chain. And I loved your point about PFIs, and I'd love to reemphasize that, because the last time we want to be talking to our vendor's vendor about engaging and allowing a PFI investigation is when we're right in the middle of a breach.
Well, and we've seen third-party data breaches where their data breach, then the brand who is unknowingly even using their service gets in the news, right?
So we could break down, and there's nothing I would love more than to walk through every control this morning and just dive into this stuff. I'm a geek like that. But one of the things we particularly wanted to call out was identity and access management, because it really represents approximately about a third of the standard. And if you look at the various laws that get into the nitty-gritty details about control requirements and the like, identity and access management is a common theme there as well. So we're talking about, governance. How do we govern who's going to access our systems and how they're going to do it, what they're going to have access to, who's going to manage this. We're talking about authentication, and I don't know if folks saw the presentation earlier this morning. The Family Feud style was fantastic, but one of the points made there was about MFA. And MFA is very common, and it's not just user MFA, it's device MSA. So working with our service provider, figuring out how are they going to access our environment, and then capturing it contractually. So we have mutual agreement what that governance is going to look like, the authentication, authorization, what are they going to have access to, audit, how are we going to police all this? And that raises monitoring issues and a variety of other legal implications. So I would just call this out as one of the particular areas you want to focus on with your service providers is identity and access management. Now, I touched on there at the end, let's go to the next one, about monitoring. And this really kind of triggers a conversation about data privacy. Most folks have probably heard of CCPA, maybe GDPR. We are seeing a massive proliferation of data privacy laws, both here in the United States and around the world. Folks, like I said, I mentioned CCPA. We've got 4 other states that have adopted CCPA-like laws. I mentioned Brazil, I mentioned China. We've got a federal bill pending. Who knows if it passes? But in any event, there's a lot to be thinking about. And a lot of these privacy laws raise certain obligations in terms of how we contract with our vendors, what they can do with data. If we have a DSAR, data subject access request, is the vendor going to facilitate that? Cara, you and I were talking a few days ago about transaction data.
Right.
All those transaction details that we capture between us or our service provider, a lot of that is going to be personal information. So we have to comply with our privacy laws. Our service provider have to comply with those privacy laws, and a number of these laws obligate us to make sure that our service provider is properly compliant and facilitating, won't use that word again, our compliance. So a lot of things to think about in that context.
Yes, exactly. So, Greg.
Right, so the penetration test is also something you want to include in your contract. And I was thinking, Mikhail Gorbachev died a couple of weeks ago, and I was reminded of the line from Ronald Reagan, trust but verify. And that's what we're doing here. So our service provider, we have all the trust in them in the world. That's why we have a contract with them. But we want to verify what they do and what they do for us, because that is what's good practice, what's really solid today may not be solid tomorrow. And so we will put in our contracts a provision for pen testing where we can have a third party go into the system and look for vulnerabilities for data breaches. And so that is not only good being proactive, it's if there is a breach, we can show that we have done our due diligence. We regularly, periodically do pen testing, and the type of pen testing that we do is valid for today. So maybe it may not stop a breach, but it'll show that we've been proactive. And maybe what we do at least tempers that breach to make it not as bad as it could have been. So it's being proactive. It's always looking for vulnerabilities. It benefits both parties, and quite frankly, our service provider gets a pen test for free.
That's true. Some of the other things that you can look at are obviously their certifications. PCI DSS is self-explanatory here. And so, but we also want to look at how they, and make sure that their PCI DSS is in your contract to say, not only are you going to be PCI DSS, or you're going to stay compliant. And what happens, you also want to add provisions for what happens if they miss their ROC date next time, right? What are the ramifications? Because that obviously impacts our ROC. So additional third-party certifications such as the SSAE 18s, the SOC 1 and 2s are additionally helpful. I think that along with the ISO 27001, we've got different ISOs out there that also help with cloud certifications and high trust and the likes thereof. But that also helps me explain that, hey, they've got some security maturation there, which is really helpful for when we're looking at and vetting the third party.
I also like it from a liability perspective. Greg's going to talk about limitations in a second here, but having those, when I'm engaging with a vendor, I want to have a defensible position. Someone else has come in and independently verified or assessed this vendor's security maturity. And so the more things like that I can point to, hey, I selected a vendor, I did my due diligence, I reviewed their SSH 18, SOC 1, preferably a SOC 2, I reviewed their attestation on compliance, or preferably their ROC. And the more I can work down this list of things that I did to show that I was reasonable in my practices, gives me a better defensible position for the inevitable security incident that might arise.
That's right.
Right, so when you do have a breach and you have damages, you want to make sure that your contract contemplates that. And so you want to make sure that the parties have an indemnification clause. Who's responsible for what? If you're responsible for the other party's damages because it was your fault, you need to have that language in there. And if you're getting the indemnity protection, that indemnity protection is only so good as the insurance behind it. So we will typically ask to be a named insured on that policy, and we want to see that policy to make sure that the types of losses that we're contemplating are covered. Now, the parties will work together to try to come to an understanding of limitations of liability. Obviously, a data breach can be very expensive. It could be millions, maybe even tens of millions, depending on the severity of the breach. So a service provider is going to want to, at some point, cap its damages, be it 5 million, 10 million, maybe even something less. We, as the merchant, we want to maximize that coverage, and them as the most probable party affording that limitation of liability, they want to limit it. So they may ask for some exponent of the total amount of invoices, say for a year. I'm not great at math, so let's say $100,000 a month, 1.2 a year, or maybe some exponent of 2 or 3, and they say no matter what your damage is, that's all you're going to get from us. So that's just something that you'll have to negotiate with the service provider, and for the merchant, they just have to come to an understanding of this is the best that we can do, can we live with that, and if so, you can go ahead and execute the contract.
So lastly, we just wanted to put out a couple of additional considerations. Confidentiality, I think that speaks for itself. But also consider your exit strategy. In our contracts, we also think what happens when we're done with our contract or we want to use somebody else. What is your exit strategy? Do you have a transition period? What are your rates for that transition period? What happens if you go beyond that transition period? I mean, and so those are all things you want to have predetermined because you will be at a disadvantage if you are negotiating those things at the end of your contract. I've been there, done that, and it's not pretty, so you want to negotiate that up front. So, Todd, why don't you wrap it up for us?
So, lots to think about, and I hope that what we have shared with you this morning has been helpful to give some additional perspectives on how merchants and service providers should be thinking about contractually. You know, the first thing I started talking about was scoping. We had to first figure out, is this vendor in scope or out of scope? And all too often, we're working with our vendors, no, I'm out of scope. I don't have to comply with PCIDS. How many times have we heard that story?
A lot.
And a lot, yeah. But now with the new standard, and I'd suggest you look at it, there's kind of a two-way test. Are they in scope or are they not in scope? And you have to be not out of scope, it's and. So very important considerations. Are they in scope, out of scope? If they're out of scope, still think about using PCIDS, very mature standard to consider. We then talked about some of the controls and requirements we would stick in contracts. And I talked about, and then Greg expanded upon what we would want for breach notification. To use the old saying, as Greg was saying, it's a matter of when, not if, unfortunately. So planning for this, having the mechanisms contractually in the contract. When are they going to notify? What kind of cooperation am I going to get? Are they going to turn over the PFI report or other kind of forensics reports that get created? All that stuff we want to agree to up front rather than on the spot, because when a breach happens, unfortunately, the merchants and service providers' interests diverge. So let's think about it now. I then talked about things that, Cara then walked us through fourth parties, and we talked about supply chains and how breaches ripple across the supply chain, and someone who's 2 or 3 degrees removed from us may impact us, and certainly we may have PCI and other legal compliance obligations that necessitate that these things flow upstream. We talked about identity and access management. We talked about privacy, and privacy is a big thing. The people who sit on the other side of our companies who deal with and tell us what we can do with data, we need to partner with them and understand what do we need to have contractually with our service providers so that we can facilitate our privacy compliance. Greg walked us through pen testing, which is a great mechanism to really see are there material vulnerabilities? We had Log4j happen over the Christmas holidays. Doing pen testings is a way to ferret out, along with scans, to see, do we have any existing vulnerabilities that really need to be rectified? But it doesn't have to be an adversarial process, as Greg was sharing with us. This is a great chance for us to come together and really understand where things are and come to mutual terms and just understand the maturity of the product and where it sits from a security perspective. Cara, you walked us through some other standards, great way to create that kind of defensible position. Greg then talked about liability, and you mentioned insurance, and one of the great things about insurance is it's become, well, I'm not sure it's a great thing, but it's become very hard to get. But as a part of that process, there's very comprehensive assessments. I've got clients who are receiving 100, 300-page questionnaires from their insurers. But when we know that someone else has got insurance, presumably they've gone through the same process, it gives us that added comfort that someone else has done the deep dive into this vendor. And then, Cara, you concluded us with talking about confidentiality and the exit strategy. These things come to an end. Let's plan for it now so that we know exactly what's going to happen when when we go part ways. So, folks, I hope this was worthwhile presentation. And I think in the minute we have left, we'd love any questions folks may have. Yes, ma'am.
We often deal with service providers who have sort of a take it or leave it contract.
Yeah.
Do you have any strategies for working with that?
Isn't that hard? Because in the take it or leave it process, they may tell us, first of all, we're out of scope, and no, we're not going to comply. Heads are nodding, exactly. And then the limitation on liability is pennies, and so there's no real recourse there. And then the security posture, they are what they are. And their argument's going to be, look, this is the price I'm offering. If you're asking for the what's a safe car to pick out, the Bentley or whatever, it's a heck of a lot more. It's a hard one, but it's a matter of upfront, early on in the process, really coming to terms before we get down this process with the vendor and, here is what I'm looking for from a security perspective. Are you the right vendor for me? I think one of the great things with the new standard, no, I'm not getting paid by the SSC, is the fact that there is this comprehensive scoping process which has been laid out directly in the standard, which gives us as merchants a bit more leverage when we're negotiating with our merchants to say, here is the test, it's not me, it's them. You're in scope, you're not.
Yep. And we've had success. We've collectively created a security requirements document for folks that are out of scope. And what it does is it pretty much follows the streamline of the requirements of PCI SSC without actually saying, because they're not in scope. And so we've done that, included SLAs, included service level agreements, and also data privacy, pen testing. That's all part of our security requirements document. And so then you get to a level of comfort that, but at least we have a template that we can begin with that's been very, very helpful for us.
Great point. Thank you.